Appellate jurisdiction. Rule 7. Regional Appellate Board. Section 1. Composition. The Regional Appellate Board, RAB, shall be composed of a senior officer of the Napalcom Regional Office as chairperson and one representative each from the PNP, and the Regional Peace and Order Council, RPOC, as members. The RPOC representative shall be designated by way of a resolution of the Council, and the PNP representative shall be designated by the PNP Regional Director. The designations shall be confirmed by the Vice Chairperson and Executive Officer of the Commission. Section 2. Quorum. The presence of the chairperson and any one of its members shall constitute a quorum. If the chairperson or any member is related to the complaining witnesses or respondent within the fourth civil degree by affinity or consanguinity, she shall be disqualified from participating in the deliberation of the appeal. In case of disqualification of the chairperson, a RAB chairperson from another Napalcom regional office or another senior official of the Commission shall be designated by the Vice Chairperson and Executive Officer to sit as chairperson of the board in the disposition of that particular case. Section 3. What are appealable? The following are appealable to the RAB. Decisions of the city/municipal mayors and the chiefs of police in the exercise of their disciplinary powers under Section 41A of RA 6975 as amended. Decisions of the PLEB or the PNP Regional Director in the exercise of their disciplinary powers under Section 41A of RA 6975 as amended where the penalty imposed is demotion or dismissal from the service. Decisions of the PNP Regional Director or equivalent supervisor in the exercise of their disciplinary powers under Section 4L(b) of RA 6975 as amended, where the penalty imposed is demotion or dismissal from the service. Decisions of the PNP Regional Director in the exercise of its summary dismissal power W under Section 42 of RA 6975 as amended where the penalty imposed is demotion or dismissal from the service. Rule 8. NATLONAL Appellate Board. Section 1. Composition. The National Appellate Board, NAB, shall be composed of the four regular commissioners, chaired by the Vice Chairperson and Executive Officer. Section 2. What are appealable? The following are appealable to the NAB. Decisions of the Chief of the PNP where the penalty imposed is demotion or dismissal from the service. Decisions of the Inspector General affirming the resolution of the Regional IAS or the Prosecution Division of the National IAS dismissing the complaint for lack of probable cause. Rule 9. Secretary of the Interior and Local Government. Section 1. Jurisdiction of the Secretary. Decisions of the RAB and the NAB may be appealed to the Secretary of the Department of the Interior and Local Government. Rule 10. Civil Service Commission. Section 1. Appellate jurisdiction of the Civil Service Commission. The following are appealable to the Civil Service Commission, CSC. Decisions of the Secretary of the Interior and Local Government in the exercise of his appellate jurisdiction except decisions of the NAB affirming the resolution of the National IAS dismissing the complaint for lack of probable cause. Decisions of the Napalcom N-Bank as summary dismissal authority except decisions approving the dismissal of the complaint for lack of probable cause. Special provisions. Rule 11. People's Law Enforcement Board, PLEB, CRADLON, function, composition, term of office and quorum. Section 1. Creation. The Sangguniang Panlungsod/Bayan in every city and municipality shall create such number of People's Law Enforcement Boards, plebs, as may be necessary, provided that there shall be at least one PLEB for every 500 city or municipal police personnel and for each of the legislative districts in a city. Section 2. Functions, powers, and duties. The PLEB has the power to hear and decide citizens' complaints formally filed with, or referred to it against any uniformed member of the PNP. Section 3. Composition. The PLEB shall be composed of the following. A member of the Sangguniang Panlungsod Garis Miring Bayan chosen by the respective Sangguniang. A punong barangay of the city or municipality concerned chosen by the Liga ng Mga Barangay, and 3 other members, who can be removed only for cause chosen. by the City/Municipal Peace and Order Council from among the respected members of the community known for their probity and integrity, one of whom must be a woman and another, a member of the bar, or in the absence thereof, a college graduate, or the principal of the central elementary school in the locality. The chairperson of the PLEB shall be elected from among its members. Except as provided in this section or as may be provided by law, a public official or employee is disqualified for appointment or designation as member of the PLEB. Applying the provisions of Article 152, Chapter 4, Title 111, Book 2 of the Revised Penal Code, the members of the PLEB are considered persons in authority. Section 4. Resolution and Executive Order constituting the PLEB, the Sangguniang Panlungsod/Bayan shall pass a resolution formally organizing the PLEB. A copy thereof shall immediately be submitted to the city/municipal mayor who shall, within 5 days from receipt of the same, issue the appropriate executive order adopting the resolution of the Sangguniang concerned. A copy of said executive order shall be furnished the Napolcom Regional Office within 10 days from issuance. Section 5. Term of Office. The term of office of the members of the PLEB shall be for a period of 3 years from assumption of office unless sooner removed for cause. Such member shall hold office until his/her successor shall have been chosen and qualified. The tenure of office of a PLEB member who has been designated as such by virtue of his election to the Sangguniang Panlungsod/Bayan or his membership with the Liga ng Mga Barangay ends upon the expiration of his term of office as Sangguniang Panlungsod/Bayan member or as Barangay Chairman/Punong Barangay. If re-elected, and subsequently redesignated to the PLEB, he must take a new oath of office. Section 6. Budget Allocation. The annual budget of the city or municipality shall include an item and the corresponding appropriation for the maintenance and operation of their local plebs. Section 7. Quorum. The presence of three members of the PLEB shall constitute a quorum, provided, however, that a vote of at least three members shall be required in rendering a decision. If for any reason, the chairperson is absent or is disqualified from participating in the hearing, the members, there being a quorum, shall elect from among themselves a temporary chairperson to perform the duties of a chairperson. When a PLEB member, after sufficient notice, fails or refuses to attend the hearings and or deliberations of the board without any valid and justifiable reason and it could not proceed for lack of quorum, the chairperson, or the designated presiding officer may request the Sangguniang Panlungsod/Bayan or the Liga ng Mga Barangay or the City/Municipal Peace and Order Council, as the case may be, to designate a temporary representative to enable the body to constitute a quorum, provided that such temporary representative shall act as such only for the specific case. Section 8. Disqualification by reason of affinity or consanguinity. The chairperson or any member of the PLEB who is related to the complainant or respondent by affinity or consanguinity within the fourth civil degree shall be disqualified from participating in the proceeding and the case shall be tried by the remaining members, provided that there is a quorum. In the event that the PLEB could not proceed with the hearing for lack of quorum, the Peace and Order Council, the Sangguniang Panlungsod/Bayan, or the Liga ng Mga Barangay of the city/municipality concerned shall appoint a temporary member for that specific case only. Part 2. Common Provisions. Rule 12. Venue. Section 1. Venue. The administrative complaints or cases against any PNP member shall 11 be filed before the disciplinary authority or IAS having territorial jurisdiction where the offense was committed. Section 2. Transfer of venue. The disciplinary authority or IAS or their authorized officer may, upon motion of either party, order a change of venue for administrative cases pending before their respective offices on the following grounds. When any of the parties is exerting efforts to harass, intimidate, coerce or unduly influence the other party, his witnesses or immediate members of the family to withdraw the complaint or retract their statements, or when there is an imminent and direct threat to the life and limb of any of the parties so as to frustrate the successful investigation of the administrative case, or when any of the parties is harmed the cause of which or the motive is closely related to the pending case, or to better serve the ends of justice. Rule 13. Commencement of complaint. Section 1. How initiated. An administrative complaint may be initiated by filing a written sworn statement before the disciplinary authority or the loss, accompanied by affidavits of witnesses, if any, and other evidence in support thereof. The complaint shall be accompanied by a certificate of non-forum shopping duly subscribed and sworn to by the complainant. If the complaint is not accompanied by a certificate of non-forum shopping, the complainant shall be required to submit the same within 5 days from notice, otherwise, the complaint shall be dismissed. If the complaint is verbally made, the disciplinary authority or loss or their authorized officer shall assist the complainant in preparing his/her complaint affidavit and other documents in support thereof. In case of a letter complaint, which is neither W1 de oath nor based on official reports, the disciplinary authority or loss or their authorized officer shall require the complainant and witnesses to affirm their signatures and to execute affidavits to substantiate the complaint. Such complaint shall likewise be accompanied by a certificate of non-forum shopping. An anonymous complaint may be the basis of a formal complaint provided that the material allegations contained therein may be validated by the disciplinary authority or IAS or their authorized officer. Section 2. Contents of a complaint. The complaint shall contain the following: full name, address, and contact information of the complainant. Full name, rank and station or assignment of the respondent/S, and a narration of the material facts which show specifically the act or omission attributable to the particular respondent/S constituting the offense allegedly committed, the place, date and time of commission of the offense. Section 3. Initial evaluation of the complaint. Upon receipt of the complaint, the disciplinary authority or IAS or their authorized officer shall immediately record it in a logbook and conduct the initial evaluation to determine if it has jurisdiction and thereby docket the same for pre-charge investigation or for formal charge in cases before the PLEB, or refer it to the appropriate disciplinary authority, or treat it as a grievance/request for assistance and refer it to the concerned office. The evaluation report recommending for the dismissal of the complaint or referral to the appropriate disciplinary authority or grievance committee shall be approved by the disciplinary authority or IAS or their authorized officer. Rule 14. Pre-charge investigation. Section 1. Pre-charge investigation. If the complaint is approved for pre-charge investigation, the disciplinary authority or IAS or its authorized officer shall direct its docketing in the pre-charge investigation docket book by stamping on the face of the complaint and its approval, the time and date of receipt, recording and assigning a case number to it, and designate the officer who shall conduct the investigation. The investigation shall include the examination of records and documents submitted by the complainant and the PNP member complained of, as well as documents readily available from other government offices for the purpose of determining the existence of probable cause. Section 2. Duration of the investigation. A pre-charge investigation shall commence by furnishing the PNP member complained of with a copy of the complaint and its supporting documents not later than 3 days from docketing thereof. The respondent may then submit his comment/counter affidavit within 5 days from receipt of the complaint, provided however, that failure of the respondent to submit his comment/counter affidavit shall be construed as a waiver thereof. Upon receipt of the counter affidavit or comment W1 de oath, the pre-charge investigator may now determine whether probable cause exists to warrant the filing of a formal charge. The pre-charge investigation shall be terminated within 10 days from receipt of the comment/counter affidavit or upon the expiration of the period to submit the same. However, if necessary, the parties may be required to appear for clarificatory questioning provided that they are notified 3 days before the scheduled appearance. The parties may already identify and affirm their respective pieces of evidence. The investigator before whom said documents were identified and affirmed must so indicate such facts in the minutes of proceedings, to include matters clarified and attach the same with the records of the case. No motion for extension of time to submit comment/counter affidavit or any other dilatory motion shall be allowed except upon meritorious causes and the filing thereof does not interrupt the reglementary period for the submission of the comment/counter affidavit. Section 3. Pre-charge investigation report. Within 5 days from the termination of the pre-charge investigation, the investigating officer shall submit to the disciplinary authority or IAS the pre-charge investigation report for approval together with the complete case records to include the formal charge. In the absence of probable cause, the complaint shall be dismissed by the disciplinary authority or IAS or its authorized officer. Section 4. Motion for reinvestigation. The complainant may file a motion for reinvestigation to the disciplinary authority within 3 days from receipt of the resolution of the investigating officer/unit dropping or closing the complaint for lack of probable cause on the ground that palpable mistake was committed in the appreciation of the complaint, counteraffidavit, and other supporting evidence. Only one motion for reinvestigation shall be allowed, which shall be resolved within 15 days from receipt thereof. Section 5. Docket entries. In all instances, during the pre-charge investigation and until its termination, appropriate docket entries must be made by the responsible person of the unit. Rule 15. Filing and assignment of cases to summary hearing officers. Section 1. Formal charge. After a finding of probable cause, the investigating office shall formally charge, under oath, the P&P member complained of. The formal charge shall contain 1. A specification of the charge/s, 2. A brief statement of material or relevant facts, and 3. The presence, if any, of aggravating circumstance/s. It shall be accompanied by certified true copies of the documentary evidence, if any, including the sworn statements or judicial affidavits of witnesses. The office tasked by the disciplinary authority to maintain the records of administrative cases shall enter the case into its official docket by stamping on the face of the formal charge the time and date of receipt and assign a case number to it. The case shall be deemed formally filed and pending upon receipt and entry of the same in the official docket of the disciplinary authority or IAS. The office tasked to maintain the docket of administrative cases shall inform the Discipline, Law, and Order Division, DLOD, Directorate for Personnel and Records Management, DPRM, of the pending cases as well as the P&P unit where the respondent is assigned. Section 2. Assignment of hearing officers. Except in cases filed before the PLEB, the disciplinary authority or the law shall in 5 days from receipt and docketing of the complaint, assign and transmit the same to a summary hearing officer.